Good afternoon, Advocate Thatcher.
Good afternoon, Chief Justice.
Are you well?
I have an incredible cold and a huge bout of hiccups, so I'm afraid what I say is going to be punctuated by hiccups.
I'm sorry to hear that. Yes,
Okay.
yes. For how many years have you practiced law? I'll pretend that you've never been here, just so that we warm up first.
I started at the bar in January 1985, so that's, 33 years.
And what did you focus on? Which areas of the law did you focus on?
Well, when I started, they had the compulsory system of the pro deo system, so for the first 5 or 6 years of your practice, many trials used to do about 4 or 5 pro deo trials a month. So that was the criminal aspect of it. And I gradually drifted into motion court and more civil work. And, you know, as you get more senior, and my preference was for the civil work, so you tend to lose contact with the prosecutors and the magistrates and the attorneys and drift away from the criminal side. So it has been the civil side. Yes.
And without in any way fearing that somebody would say you are arrogant or something, how much did you begin to flow in lucrative work?
Well, I'm not sure that.
I was trying to.
I have a simple lifestyle. I don't need money.
You don't need it?
I don't need money. I don't need a lot of money. I have a simple lifestyle. I'm not a materialistic person. I've just been incredibly fortunate. At the bar, our overheads are very low in comparison, for instance, with attorneys. So
yes.
if you do have a good month, there's a very direct correlation between the good month and what goes into your bank. You feel it. Yes. But it's been steady.
Yes.
I've been very fortunate. You might have seen from the cases that I've referred to in my application. I was in demand with senior counsel, so I had a lot of very interesting cases with very experienced silks, so I was very lucky.
And I don't know if the rule still applies. Is it some 2/3 or something that the junior would charge of silk?
Well, when one starts out, the customer is half. And then as one gets more senior, it's really up to the senior to decide how much worth you've been to him. And he would then turn around and say, well, 2/3 this time. But you would generally, a junior would start off on half.
Yeah, I used to insist on 2/3. But anyway, I thought you would need money in order to be able to assist those who need assistance, even at the bar. Mm-hmm. The more money you have, the more possibility you have to bring in a junior, even if it means you would give him or her something from your own pocket.
Yes, yeah. It's
not so much about you, but others that you could help.
Yes,
I thought you would think about it along those lines.
I certainly, that's one nice thing about the bar is the collegial atmosphere. And I don't have a huge senior silks practice. The opportunity to employ juniors is limited, but there were 2 or 3 occasions when I brought juniors in, and it's always been on a fairly urgent basis, and you ask them for a draft, and unfortunately, time hasn't permitted me to wait for the draft. But, yes. On a daily basis, I have people coming into my chambers. The other day, I had a lady come in an absolute panic, and she was about to consult with the municipality. And I said to her, why don't you just ask your attorney to come and consult in my chambers? So we went through that process, and I assisted her there. And
I don't understand. Was it a member of the public approaching you?
No, a junior advocate.
Okay.
She came for advice, and I thought it was urgent, and I suggested to her, just tell your attorney we'll meet in my chambers. And we had a joint consultation, and she went away, and we settled a draft together. And that's the sort of thing. And I think literally almost on a daily basis, I think doing this legal writing lecturing helps them to get to know me and me to know them. And juniors spent a lot of time in my chambers, and it's an absolute pleasure.
Yes. So you were not initially going to do the matter?
No.
But when you were consulted and you advised that maybe he or she and the attorney could come in, you then got involved?
No, I made it quite clear that I wasn't part of the team.
Okay.
I was just there to assist.
To help,
Yeah,
yes. Now, I just want to give you a chance, since you were here before. Just tell us why you should be the one. I won't interrupt you. I'll just keep quiet.
Well, Chief Justice, perhaps I would like to simply refer to the report that the KZN Society wrote about me. It's not often that people in our profession have a chance to be viewed by your peers, but at paragraph 18.3, the report says he would, in our opinion, be an asset to the judiciary, and his experience in litigation would be invaluable. It's high praise from my colleagues, and I was humbled by that. I was somewhat taken aback by the Black Lawyers Association, who said that as I'd only acted for 5 instances, I was therefore not fully exposed to the functioning of the High Court. It made me go back. I did appear before the Commission in October 2015, and I came across the report that Aft wrote about me then. And it says that I've acted on 3 occasions. He has served the bar well by educating pupils. He has a maritime law practice, has reported judgments in maritime law. He is a humble person and has a progressive disposition. His dedication to the bar's pupillage program demonstrates his inclination to develop new advocates, and it was agreed that he will make a good judge. That was Aft's report to me in October 2015. So I'd prefer to have it from the words of a third party than me.
What do they mean by dedication to the pupillage program?
I've always enjoyed writing, and in the early 2000s, pupillage started to become more formalized, and they started to have lectures, and I started to prepare the pupils for the legal writing exam. There's a syllabus. It's a weekly syllabus. There will, for instance, on the first week will be opinions, the second week particulars of claim, and so on. I just found that asking new pupils to do exam questions, they weren't ready for them. So over the years, I've prepared simple questions to get them to write, as opposed to debate the substantive law. And I meet with the pupils once a week, every Tuesday. I give them a little explanation, and then they go away with the exercise I've set them. They deliver it to my chambers every Friday, and then I mark them, and then the next week we go over them. I there are lots of common errors that we go through the exercises like that, and we do 1 a week for the first 6 months of the year. And it's very satisfying to see their improvements and the confidence that they grow, and they really appreciate it.
So you out of your time, you have dedicated a portion to assist pupils.
To prepare them for to go through the legal aid syllabus with them.
Yes, and you volunteer. It's not as if everybody must do it. You've decided to make yourself available.
No, it's been an entirely voluntary thing. And as I say, I've always had an interest in writing, and I'm fortunate in that English is my first language. For someone to have to start legal writing where English isn't their first language, it's a daunting thing, where the position of a comma can change the whole sentence or statute. So I have admiration for people who have to practice in a second language.
Yeah.
But it is an entirely voluntary thing, and it's been a pleasure, and I enjoy it.
Yes. All right. Anything else you want to add?
No, I don't think so. I know the Judge President is inundated with people requests to act. I haven't pestered him.
People do come and say, remember me. It never used to be done. People used to wait to be approached. That was a dignified way of having it done. I never knew that people would sort of approach and say, please, when are you going to invite me?
Yes.
So they do that these days?
I think Judge President Jappy is probably in a better position, but
Yeah, I see he's nodding.
I understand the position is he's inundated with people.
Okay, all right. DJP?
Thank you, CJ. Mr. Thatcher, good afternoon.
Good afternoon, DJP.
We have met earlier on. What will you regard to be your major contribution to the bench should you be appointed?
I would like to think that I can contribute to the more efficient running of the division. I think over the years, I think increasingly there should be more case management, closer case management. I think that the rules board is formulating rules to give judges orders in case management consultants, give them teeth, that the side's got to do something by such and such a date, failing, which, like we have with discovery and further particulars. And I think the efficiency of the division could be improved by a lot more individual case management. And I think I could help with that.
Yes. Oh, well, what do you mean by individual case management?
Well, there's a system at the moment, I think, where 120 cases are set down on a Friday. It's too easy for people who want to retard the progress of the litigation to get past that, I think, in the present system.
Yes. In the light of the demographics in KZN division, do you think, or would you say, your appointment will in any way benefit the transformation?
If one is going to count heads, I am what I am. I see in the AFT's report they say that there ought to be 1 and 1.4 judges, white judges in the division. It's clearly not going to help the ratio or the proportion. But I would like to think that the reports, for instance, of AFT, my relations with my colleagues see me as a person who treats everyone with respect and has the right values. But from a point of view of colour, clearly I'm not going to help.
Thank you, Chief Justice.
Thank you, Deputy Judge President. MEC?
Thank you, CJ. I think I'm covered. He's already answered the question I wanted to ask.
Thank you, MEC. Commissioner Norman?
Thank you, Chief Justice. Good afternoon, Mr. Thatcher.
Good afternoon, Commissioner.
We are colleagues,
Yes.
and I am aware of your involvement in pupillage matters.
Yeah.
But in answer to one of the questions by the Chief Justice, you did indicate that, look, sometimes you don't have time to wait for a draft. And I don't want to misunderstand that. By saying that, do you mean that you don't work with juniors because you are impatient to wait for drafts, or what did you mean?
No, it was just it were 2 or 3 occasions where I felt that I could bring someone in, but there was an urgent element to it, and unfortunately, perhaps they were just the wrong cases. Most of the cases where I've led people, I've actually been approached by the junior counsel to lead them. It hasn't really been the other way around.
So in other words, you have not had matters where you felt on your own that you would want to involve a junior, and in particular a black junior?
I just felt that there hasn't been the right occasion, yeah. And once, yeah.
All right. Thank you, Chief Justice.
But I really don't believe I'm an impatient person.
Thank you. Thank you. I just wanted to clarify that. Thank you.
Why did you seem to think that none of those juniors would be able to work fast as circumstances demanded?
There is an imperative. I mean, I've learnt a lot from being junior to senior counsel,
yes.
and it is the way to go. But unfortunately, the size of my practice doesn't actually enable me to do it
Okay.
on anything like the scale which ought to happen and which happened to me. So I was very fortunate.
So it's not about agency, it's about the size.
Both, a bit of both, yeah.
Okay. Thank you very much, Advocate Thatcher. Your excuse.
Thank you.